What was just your initial take on even the concept of like a Textalyzer machine? What did you think when I told you about this?
The same as a Stingray machine that we've had a controversy here. You cannot limit the technology and make sure you preserve individuals' confidences and their privacy. So they're taking the position that in the next 6 to 9 months, they'll have a device available through a private manufacturer that will only read whether you made a phone call or texted in the recent future. Well, that means that device is scanning your entire phone to get that information. And remember, it's got to figure out how to do that for iPhones, for Samsung phones, for Nokia, for Motorola, for BlackBerry phones.
You have doubts they could do this?
I have doubts that they can limit that information. They're going to tell us, just like with the Stingray, that they can, because it behooves them to. The company will make money, the municipality gets their product that they claim will only give them limited information about whether you made a phone call or texted while you were driving. That's on the one side. On the other side, it is going to be held to be, in my estimation, unconstitutional for a police officer to show up at an accident and all of a sudden demand from everybody their phones, and you have to turn it over to them. They don't have any proof that you were responsible for the accident, that you violated any vehicle and traffic laws. They don't need any evidence that you were under the influence of alcohol or drugs. You did nothing wrong other than you may have been the victim of the accident. And now you have to turn over your phone to that officer who allegedly is going to only retrieve information about whether you made a phone call or texted in the last 20 minutes, half hour, whatever time frame. I think that that's very invasive of individual rights, and under the Fourth Amendment, federal Fourth Amendment, and under the state equivalent amendments under a state constitution will not be upheld. There's a grave difference between the argument for breathalyzers for DWIs as opposed to showing up at an accident scene and demanding everybody's phones.
Right. Yeah, it seems like with a breathalyzer, there is some type of probable cause there, right?
Absolutely. So in order for the officer to require you to take a breathalyzer, that officer has to approach you, have reasonable cause to believe that you were driving the vehicle, and then through indicia of alcohol consumption, believe that you were under the influence of alcohol. Perhaps bloodshot eyes, smelling the smell of alcohol, slurred speech, a combination of those, or you admit to the officer that you were drinking. Now that's individualized suspicion that now leads the officer to now require that you take a breath test. It is the opposite for this legislation with respect to your mobile device. The officer simply, under their legislation, shows up, has no indicia that anyone did anything wrong, and demands everyone's phones. And the Supreme Court recently held, about 3 years ago, that we are entitled to great protections of privacy when it comes to our cell phones because of this evolving technology. Now most individuals have their entire lives on their cell phones. And so therefore there has to be a search warrant before any type of a seizure or search of your cell phone can be conducted.
So I'm guessing they're going to argue this isn't a search, that it's not looking through the contents, that it's just looking to see if the device was used. Would the court find, you believe, a distinction there?
Well, we'll have to see what the technology is, and there'll certainly be challenges. But I don't think that there will be much of a distinction. Because first, and remember, it's search and seizure. First, they're seizing your phone. You've done nothing wrong. They have no indicia that you violated any law, even a minimal indicia that you violated some vehicle and traffic law. They've now seized your cell phone, and then they engage in a search. Now, it may not, in their minds, be an extensive search, but it's still a search. And there is nothing stopping them from seeing the information that's on the phone. So if an officer shows up at the scene, you hand them your phone. If you receive a phone call, they're going to see the individual who's calling you. If you receive text messages, there could be notifications on your phone. If the phone has to be opened up for them to do this search, they may see the emails that you've recently received. And I don't believe for a second that the technology can be that refined that it allows the officer to only determine what you did for the last 30 minutes without giving any information as to who you texted, who you emailed with, what the contents were, but have no other access to other information on your cell phone. It's just not believable, not reasonable to think so.
You believe the Supreme Court, should this pass and make it there, would strike this down?
I believe that the New York Court of Appeals would strike this down, and that the United States Supreme Court would both strike this down as violative of individual rights. There has to be some indicia of a violation of law. It doesn't have to be beyond a reasonable doubt or even necessarily probable cause. It could be a lower standard. But before an officer can seize everyone's cell phones, which the Supreme Court has held, we have a great expectation of privacy to, before they can seize everyone's cell phones, take them from those individuals, and look through those phones, even allegedly for limited information, I believe that the Supreme Court and the New York State Court of Appeals will both hold that there has to be some evidence that that individual that the officer took the phone from did something wrong first.
One final question. We often have this kind of balance between, we all see the need to do something here, right? We believe about 10,000 people were killed in distracted driving crashes last year. Everybody knows it's a problem. It seems like sometimes people look to the solution of taking away our rights in order to protect us from something else, right? How do you see that balance at play here?
I think that this legislation, as noble a cause as it is, because distracted driving is incredibly dangerous, is too burdensome on individual freedoms and rights and our cell phones, which have very private information about who we have in our contacts, who we text with, who we email with, where we have been recently with GPS tracking. It's too much of a burden on our individual rights. A more reasonable approach would be that the police officer could note what your phone number is and then subpoena the records from the carrier. And that will tell the officer, did you text near to the time of the accident? Did you email? Did you make a phone call near the time of the accident? That, if they have probable cause to believe that you violated some law, that you were either speeding or under the influence of alcohol or drugs, with that information, that would give them reasonable suspicion to then issue a search warrant and get that information from your carrier, which is readily available.
It happens.
All the time. It happens all the time with respect to criminal prosecution, with respect to civil litigation, that they subpoena from the carriers our records. Happens every day. I see it in our office. I see it being done with the district attorney's office, the U.S. attorney's office. We are very familiar, all of us, with prosecutions that are built upon subpoenaing records from carriers.